Hello, everyone. Welcome to the AIA Contract Documents webinar on best practices for avoiding and handling claims. We're going to go ahead and begin here today. I just want to remind everyone and notify everyone that you will receive the recording of today's webinar as well as the slides via email from AIA Contract Documents after the presentation. So just keep an eye out for that. I just want to begin with just two quick disclaimers here. First is just that the presentation is protected by copyright laws. Again, you'll be receiving those slides. So you'll have this disclaimer on those slides as well in terms of reproduction, distribution, and display. And then the second disclaimer is just that anything that our presenter goes over today should not be acted upon as legal advice. If you think you have something that requires any kind of legal attention, we just encourage you to reach out to a local attorney. So with the fun stuff out of the way, I'm going to go ahead and immediately hand it over to our presenter who's going to be taking you through the content today before I return for the Q&A section at the end. So I'll give it over to Robin to introduce herself.
Good afternoon, everyone. My name is Robin Banks, and I'm an attorney with the law firm of Goldberg & Banks in Baltimore, Maryland. Our firm, just to give you a little bit of background, represents participants across the construction spectrum. We represent owners and design professionals, CMs, contractors, and subcontractors. And we basically help clients with everything from drafting and negotiating contracts all the way through the dispute resolution process. In addition to my private practice, I'm also an associate outside counsel to the AIA Contract Documents Committee and have been involved in updating all of the major document families over the past 10 years or so. But that is not what we're here to talk about today. We're here to talk about risk management. And Ben Franklin said it best with the old adage, an ounce of prevention is worth a pound of cure. If you're aware of and can implement risk management strategies as part of your normal business practices, you're going to protect your organization if claims occur down the line. I like to think of risk management in terms of two time frames, the before period and the after period, with ground zero being either the claim or the potential for a claim. Look, we know that not every project is going to go perfectly, but for the next little bit, I want to talk about some best practices for managing risk and avoiding claims in the before period, and what to do if there's a problem on a project or claim in the after period. So up on the slide is a list of the topics we're going to talk about. Hopefully it's not too daunting. I'll try to keep it interesting for you. So construction claims. So when I think of construction claims, I picture the cartoon short where you've got a main character who's standing atop a snowy hill, and they trip and they fall and they go rolling down the hill, picking up all the snow and the tree branches and the other skiers before they land at the bottom in a giant heap. And that's because seemingly clear-cut claims against one party often involving multiple project participants and multiple different claims. And seemingly simple claims are often met with counterclaims far in excess of the original claimed value. So take, for example, errors and omissions in the construction documents by a design professional. This could result in a delay claim from a contractor for an extension of contract time. It could result from claims from the contractor and its subs for increases in the contract sum, not only for extra costs, but to correct the defective work. And on top of that, the owner may suffer direct and consequential damages as a result of the delay, which they may be entitled to depending on what the agreement says. Another example is if the owner doesn't pay the design professional or contractor in accordance with the terms of the party's agreement. So this may result in that party, the design professional or the contractor, filing a claim against the owner, which usually results in a claim counterclaim by the owner against either the design professional for errors and omissions or against the contractor for defective construction. And I can almost assure you that the counterclaim is going to be far in excess of the original claim for payment. So as you can see, the various common types and causes of construction claims on this slide often overlap. And while having the right risk management strategies in place may not ensure there aren't going to be any claims, it should make the pursuit or defense of a claim easier, hopefully, and ideally help to mitigate the losses that the parties may suffer. So, jumping into avoiding claims. The first strategy that I'm going to suggest may seem like an obvious one, but people often overlook it. Regardless of whether you're an owner, a design professional, or a contractor, you need to know who you're contracting with. How do you do this? If you're an owner, you do it through a solicitation, like an RFQ or an RFP. Use this as a way to get ideas of the experience of your bidder on similar projects like yours. What are the qualifications of the people who are going to be working on the project? You want to make sure that the person who you're hiring is a good fit for the project. You also want to use the solicitation as a way to understand some of the risks that you may be taking by contracting with the bidder. Don't hesitate to ask about terminations or debarment. And for terminations, find out the cause and get some information about that. Again, it may help to understand who you're contracting with. Now, on the flip side, design professionals or contractors who want to pursue an opportunity either with a new client or even looking to hire a new consultant should inquire about industry reputations and do some of their own investigative research. Look, we know the internet is a treasure trove of information. Also, don't be afraid to ask questions of people who you know who have worked for a particular client or with a particular client. Another suggestion is to call your insurance broker and ask if the potential client has any history of claims against design professionals or contractors, whoever you are. Oftentimes, they'll be able to provide insight into if there are claims, and if there are, how much was paid out or whether they got resolved. Sometimes that will help inform your decision. Another thing, you need to review sample terms and conditions or sample agreements that may be included with the solicitation, and determine whether these terms and conditions and agreement provisions are within your firm's risk profile. If they're not, can you take exceptions? Some owners or jurisdictions or clients are going to require you to take exceptions when you submit your proposal. Some may be prohibited from law by doing so, and others still may say if you want to submit, take the agreement or leave it. It's up to you. Now, before I leave this slide, I want to give one piece of advice as far as paying attention to your gut. If you have a bad feeling about the client from the outset, think twice about contracting with them. This doesn't matter who you are, because clients who are difficult to deal with during the contracting process, when everybody's supposed to be getting along in kumbaya, are typically no easier to deal with and are, in fact, much more difficult if a problem arises down the line. Next, do not just sign on the dotted line. I think this slide is pretty self-explanatory. You should be reviewing all contracts and proposals that are presented. You should be negotiating terms that are acceptable and within your firm's risk profile, and you should be properly administering the agreements. And in the next few slides, we're going to talk about these three topics in greater detail. First, reviewing all agreements. So owners need to carefully review, actually, let me step back for a second. Without a doubt, the most important document that you're going to sign over the course of the project is a project agreement. It's going to address what you're hiring someone or being hired to do, how you're going to pay or be paid for the services or work, and what are the terms and conditions that are going to serve as the basis of the parties' bargain. Now, on the owner side, owners need to carefully review all agreements and proposals that are furnished by the bidder in response to their solicitation, paying close attention to the clarifications or qualifications and assumptions that are included in a proposal. I would suggest it is important to know what the bidder is not providing is what they are. Also, if an owner has decided not to furnish its own agreement, but has asked the bidder to provide one, they should be carefully reviewing all the provisions to make sure that it's within their risk profile. Flipping to the contractor or design professional side, they also need to carefully review all contract documents that are furnished by the client. The contract documents include the agreement, any exhibits, and all documents that are incorporated by reference. Oftentimes, important and critical terms and conditions and flow-down obligations from higher tier agreements are going to be incorporated by reference into the contract documents. If you're not carefully reviewing each and every one of these documents, you may be missing out on key obligations that you may owe to your client or to others. The caveat to this is sometimes contracts will say, you can request, documents are available upon request. There is no question that if it says that, you should be requesting every single document, because chances are there are things in there you need to comply with, and by not requesting and reviewing them, you're missing out again on key potential obligations. Now, this exercise may seem tedious, time-consuming, and expensive on the front end, but it may save you from potential claims and great headache on the back end, especially if you get into a claim situation and you either miss deadlines or aren't providing the right documentation and can't get where you need to be. Now, before I leave this slide, one word of warning. I'm a huge fan of industry agreements like the AIA agreements that are drafted to put the risk on the party who's best able to manage it. But just because you're given what appears to be a standard industry form agreement does not mean that it is not edited. In the case of an AIA agreement, unless your client provides you with the additions and deletions report so that you can verify all the edits, you should be reviewing every single word of that document. Because these documents, as you know, are fully editable, and more often than not, parties and their attorneys are going to be modifying the contract to shed risk off of themselves and onto the other parties when they can. Sometimes these edits are not readily apparent and may not show up in track changes, so all the more reason to be careful. And I know with certain other industry agreements also, there is no track changes version. And so again, you need to carefully review every word, even if it appears to be just a standard industry form. Next, negotiation. Bearing in mind that parties are going to try to modify risk profiles, I want to talk for a little bit about some places where you should be aware that parties to an agreement may be particularly sensitive. And the first, standard of care. So every owner wants the best for their project. They want the best design professional and they want the best contractor, and they theoretically want them to perform their services or work in accordance with the highest standard of care. But this is a critical problem, especially for design professionals, because their professional liability insurance covers damage for which they're legally liable, simply stated, which result from their failure to comply with the standard of care. Now, as you probably all know, the standard of care is that same professional skill and care that a design professional performing the same or similar services under the same or similar circumstances in the locality of the project would do. But by contractually requiring the design professional to perform to a higher standard, the client may be heightening the standard of care and creating a situation where the design professional may have uninsured liability. In a best case scenario, it may give rise to a reservation of rights, and in a worst case, it could result in a denial of coverage for the loss. Now, the contractor standard of care is up on the slide as well. They're typically obligated to perform in a good and workmanlike manner and in accordance with laws and codes. And while agreeing to perform their work to a higher standard may not necessarily cause an insurance issue, it could be setting the stage for liability down the line if a completed project is not 100% perfect. And in my experience, very few projects are 100% perfect. Warranties. So I'll touch on warranties for a minute or so. Owners often want design professionals and contractors to warrant their services or work. Typical warranties are that the services or work will be defect-free and that the project, when complete, may be fit for the owner's particular purpose. Sometimes owners or clients also want the design professional or contractor to either warrant their work or warrant that they'll remedy any defects for some period of time after the services or work are complete. However, from the design professional's perspective, warranties are a death knell. They're typically excluded from PLI policies as obligations assumed by contract. Owners who include warranties of the design professional services and design professionals who agree to them risk losing out on insurance proceeds whose specific purpose is to protect them against the design professional's negligent acts or omissions or breaches of the standard of care. Now, from the contractor's perspective, warranties are fairly typical. They warrant that the work is going to conform to the contract documents and be defect-free, except as permitted by those documents. But contractors' warranties should not be absolute either. Like in the AIA general conditions, their warranties should exclude things like abuse or alterations not executed by the contractor, improper or insufficient maintenance, and normal wear and tear under normal usage. But probably the biggest area where parties seek to shift risk in a contract is the indemnification provision. Indemnification is always everybody's favorite topic. It's basically where Party A is going to contractually agree to compensate Party B for a loss suffered by Party B due to the acts or omissions of Party A. And up on this slide are the indemnification obligations that the design professional and contractor can agree to that may be covered by their respective insurances. For design professionals, they can agree to indemnify and hold harmless the party with whom they have a contract for damages, losses, and judgments to the extent that they're caused by their negligent acts or omissions. Professional liability insurance typically does not cover agreements to defend the client from day one. Most professional liability policies, not all, but most, will not pay the client's attorney's fees from the day a claim is filed alleging the design professional's negligence. The policy, however, will reimburse the client for their reasonable attorney's fees and costs recoverable by law if and to the extent the insured is found to be negligent. Professional liability insurance will also typically not cover agreements to indemnify people other than those with whom they have a contract, other than the client, unless the law of a particular state allows. So if, for example, like in Maryland, the economic loss rule is alive and well, it prevents people who are not in privity from filing suits solely for economic loss under most circumstances, then somebody who is agreed, who is not directly in privity of contract, would not be able to be an indemnity, or that is a risk outside of the contract that the professional liability insurance would not cover. Again, many states, the economic loss rule has been eroded, so you need to check your state by state. Now, professional liability insurance will also not cover agreements to indemnify for breach of contract or certain other causes of action like non-compliance with laws and codes or intellectual property infringement. With regard to breach of contract, the client is always going to have a right to sue for breach of contract, but by adding it into the indemnity provision, they get to recover their attorney's fees. With regard to non-compliance with laws and codes or intellectual property infringement, professional liability insurance will only cover these losses if they result from failures to comply with the standard of care. Now, on the contractor side, they can indemnify, defend, and hold harmless the client for claims, damages, losses, and judgments that are attributable to bodily injury, death, disease, or property damage other than to the work to the extent caused by the contractor's negligent acts or omissions. Like with the design professional, with breach of contract and a number of other things, the client would likely have a right to sue, but by adding it to the indemnity provision, they get their fees, their attorney's fees, that is, and other items that the client may try to get someone to indemnify for, again, may be obligations that they're just taking as business risks. So before I leave the topic of contract provisions, I want to go over 4 other risk-shifting provisions with you. The first is consequential damages. Consequential damages are damages a party may suffer that naturally flow from the other party's breach of contract. They could include loss of profit, loss of business, loss of resulting from business interruption, or loss of goodwill. Now, most industry forms are going to contain a waiver of consequential damages as part of their standard language. And this came out of a case in New Jersey, wound up going to arbitration over 20 years ago, where a construction manager was paid a $600,000 fee for a hotel and casino project in New Jersey, but wound up with a judgment against them in excess of $40 million because it was found liable for consequential damages due to delays such as loss of gaming and other revenue. Now, some clients try to strike the waiver of consequential damages. This is very dangerous for a design professional or a contractor to agree to because it opens that party up to unlimited liability. From a risk management standpoint, the best course of action is going to be to try to negotiate to keep it in. But if the client isn't willing to do so, a design professional or contractor can try to mitigate this risk with a limitation of liability provision. Now, contractual limitations of liability are enforceable in most states. Typical limitations of liability for design professionals are to either their fee or multiple, or to their available insurance proceeds, or to the insurance required by the agreement. Contractors' limitations of liability vary as well. Theirs could be to the contract price or some other negotiated number. But whether a client can or should accept a limitation is largely going to depend on who the client is, what the project is, and what is the design professional or contractor's scope. If, for example, the client is a public owner or not-for-profit, A limitation of liability may be unlikely because they just simply can't accept the financial risk. Also, depending on the nature of the project and the nature of the risks associated with the services or work to be performed, will determine whether the owner will be more or less likely to agree to a limitation of liability. Another risk-shifting provision is a liquidated damages provision. Liquidated damages are damages that an owner may seek to assess against a contractor in a contract for failing to achieve substantial completion within the contract time. Liquidated damages should be a reasonable estimate of the damages that the owner is going to suffer if substantial completion is not timely achieved. They can't be used as a penalty to penalize the contractor. Now, a lot of contractors actually prefer LDs because it fixes their liability to the owner for delays, whereas, like I said before, it could be unlimited. It's pretty unusual for owner design professional agreements to have liquidated damages, although a design professional may wind up subject to them if they're under a design builder or a contractor, and those parties have it in their own agreement with the owner. Last contract provision I want to talk about is instruments of service. This is mostly for design professionals. I'm finding out that in today's day and age, most owners want to own not only the physical manifestations of what you do, but they also want to own your intellectual property as well. Sometimes they want to use it for extensions of the project. Sometimes they want to use it to build identical structures. Other times they just want it. And they do so with provisions like all work shall be owned by the owner, shall be a work for hire. The problem, though, is if they do own your instruments of service and injure your damage results, you may wind up being liable. The way to mitigate this risk is in actually the AIA's V documents, where you have a caveat in there that any use of the documents without your involvement is going to be at the user's sole risk and without liability to you, and to get an indemnity and defense from the client for any claims and damages, losses, or judgments that result from their use of the instruments of service without your involvement. Administration of contracts. So you've now signed on the dotted line, and now you're off to the races and are going to start performing the contract. The first thing that you should do is somebody on every side of the table should be doing a careful audit of every provision of the contract and looking for each of the items up on this slide, because, and any other ones for that matter, that impose an affirmative obligation on you, the client, or the party who's involved. Regarding the scope of work, you need to know what you're hiring someone or being hired to do. Design professionals and contractors should not assume responsibilities outside of their specific scope of work without proper authorization from the client. I call this the no good deed goes unpunished rule, because if you do this, then number one, not only do you risk not getting paid for your services, but you may be exposing yourself to greater potential liability. Next thing is payment for services. So it's actually payment in a couple of ways. Number one is payment for services. You need to know when your invoices or applications for payment are due so you can get paid. If you're an architect or engineer and have CA duties, what are the time requirements for certifying payment, for reviewing payment apps, and certifying payment to the contractor? And when do you need to pay your subs and consultants? Again, all things which you should be paying attention to and taking note of. The next is timing of performance. These days, more and more schedules are being included as a contract document. What this means is, if one party doesn't perform according to the schedule, then they're technically in breach of the contract. So the parties may technically need to amend the contract as necessary to reflect the adjustment of dates. Also, in light of this crazy world situation we've been living in over the last year with COVID and a variety of other things, you need to pay specific attention to provisions that give you schedule relief, like delay provisions or force majeure provisions. Know when you need to provide notice of delay and what other documentation or other information you may need to provide. Changes in extras. Owners, how can you modify the design professional or contractor scope? Design professionals and contractors, what do you need to do to get paid for those services? Number one, you probably need written authorization. Number two, you probably need to tell them that you think they're asking you to do something outside of your scope. And number three, you probably need to provide some documentation to them. Again, you should be noting all of these things once the contract is signed before you start to perform. For submission of claims and dispute resolution, you need to be paying attention to timing requirements for submission and what other documentation you may need to provide. And lastly, for confidentiality, more and more owners I find are adding confidentiality agreements, provisions to agreements these days. If you're a design professional or contractor or opposing party, you need to make sure that you're paying close attention to what these provisions are and that you're making sure that you're communicating them to the project team and have ways to enforce it. So up on this slide, when you first, most of what people do is they take their contract, they briefly look it over, they either used to stick it in a drawer or a file, and now they save it to their system, and they never look at it again until there's a problem on a project. I would submit that the better course of action would be to do something like I have up on the slide now, which is prepare a sample table, which down the left-hand column, you have all of the various obligations or things that you need to be aware of in the agreement. Again, what do you need for schedule relief, for payment changes, and whatnot. Then, if there are timing requirements, for example, if you have a changed condition, differing site condition, under the AIA A201, you have 14 days to notify the, I believe, owner and architect that you have observed the new condition, the differing condition. So you put 14 days in here, and any documentation you need to provide. If there's any miscellaneous information, somebody may say that you need to put notice of claim on every claim. Whatever the contract says, this way you have all of the information in one place, and you can distribute it to the people on the project team who need to know this information and can watch those things like the timing and the documentation to make sure you're dotting all the I's and crossing all the T's. Now, enough about contracts. Let's talk about communication and risk management. In today's digital world, we've come to expect, both professionally and personally, that we're going to send and receive immediate responses to everybody's emails, texts, and social media posts. But in the workplace, this is especially dangerous. When an issue arises on a project and clients and your contracting partners want answers, you're tempted to fire off immediate responses so that you can allay their concerns. But these immediate responses are often not, in the infamous words of Judge Howler in my favorite movie, My Cousin Vinny, often lucid, intelligent, or well thought out. The other equally problematic issue is that these responses are also discoverable by the other side in litigation, even if you think you're deleting them. So when it comes to communications, I have a few suggestions. Number one, communications within your organization are always best in person. I know in today's work environment where a lot of us are remote all or part of the time, it's much harder to peek your head into your supervisor's office and say, hey, I think we've got a problem. We need to talk about this. But communications are always best in person, again, either over the phone or in person. Second, if you're going to use email, reread the substance of each email, every substantive email, more than once, and make sure it says what you want it to say and nothing you don't. And most importantly, stop before sending any written communication that could be construed as an admission of wrongdoing. Next is to develop early reporting procedures. So most organizations take pride in hiring employees who think independently and problem solve. Under normal circumstances, this is a trait that we want to foster and to encourage. But a claim or a potential claim is not a normal circumstance. You don't want employees going rogue in an attempt to try to fix an issue on their own before anyone finds out, or by trying to impress their boss. Because by doing so, they may wind up in inadvertently or intentionally admitting to wrongdoing or waiving either the attorney-client or some other privilege that we're going to talk about a little bit later. Your organization should have policies in place that encourage employees at every level to be reporting concerns or issues on jobs to their supervisors immediately. This is that sign on the highway, if you see something, say something. Supervisors should be reporting issues or concerns to management, and management should put into place an action plan, which includes many of the following measures that I'm going to talk about now and that we'll talk about through the rest of today. One of these response measures should be the designation of a single point of contact to the extent possible to respond on behalf of the organization. It helps the organization maintain control of the messaging and the information being put out. A second response measure is to immediately discourage the use of all written communications to discuss the issues or concerns where possible. Like I said before, number one, it'll be discoverable in litigation. Number two, it may be construed as an admission of wrongdoing. And number three, it could damage your credibility before the trier of fact, whether that trier of fact is a judge, a jury, or an arbitrator. Next, with experience comes wisdom. Like I said before, not every project goes off without a hitch. Otherwise, I would probably not be here talking to you today. But I would suggest you use problem projects as a learning experience. Keep a log of these projects. Review lessons learned within your organization on either an annual or more frequent basis. And you should be modifying your organizational practices and procedures based on that knowledge. So you can use that information when you're drafting or negotiating contracts. If, for example, you know you've had particular difficulty with an issue, you can either add it into your contract, or you may want to take a little harder stance on negotiating. Indemnity, for example, or standard of care could be one. You also want to use information from problem projects to update your HR manuals, perhaps with regard to communication or process in the event of a claim. Our last topic in the sort of before period, before the claim, is retention of documents. So picture this. The project has now ended, and you've got 1 million documents taking up space in your physical office and in the cloud. Can you just get rid of it all? The answer is a definite no. Document retention is important because it helps you pursue or defend a case, and it helps avoid the potential for discovery sanctions related to spoliation of evidence. So what should you be keeping? Well, you need to keep all documents that relate to the design professional or contractor scope of work. You need to keep all project-specific information that you either prepared, reviewed, or certified, and you need to keep important project correspondence. Now, with regard to the scope of work, you need to keep the agreements and all amendments or exhibits, scope documents and specifications. If you're a design professional, you should be keeping all instruments of service that were prepared and all backup for them. Project-specific information should be either design criteria, RFIs, site visit reports, change orders, submittals, certificates of substantial or final completion, and warranty and closeout documents. Again, you should be keeping all of these documents in your file. And lastly, with respect to project correspondence, you should be keeping all project correspondence with either people within your organization, with other project participants, including the client, and third-party reviewers. Now, do you have to keep it forever? Well, it depends on two things. Number one, what your agreement says, and number two, what the law says. These days, more and more agreements include requirements for how long you should keep project-related documents. A lot of owner agreements have audit requirements where they can review all of your payment documentation and other information for up to 3 years or 5 years or some period like that. And so if your agreement provides it, you should be keeping everything or whatever it says. Now, in addition to that, the law has requirements too. The law is two parts, really. It's the statute of limitations and the statute of repose. The statute of limitations is the period that you have to bring a suit from when you knew or should have known of the harm. And the length of the statute of limitations is going to vary by state and by the type of harm. On top of that, you have the statute of repose. And the statute of repose is the time after which you can no longer bring an action against the design professional or contractor. In many jurisdictions, the trigger is when the improvement is first available for its intended use, but that's not the case everywhere. Many states, the statute of repose is 10 years, but it may be as short as 6 or even longer than 10. And also note that you typically have to bring the cause of action within the statute of limitations as well. So if, for example, let's say we're in Maryland, you've got a 3-year statute of limitations and you've got a 10-year statute of repose. If you discover a defect in year 3, then you have to bring your cause of action within year 6, even though if you were to discover it later on, you'd have 10 years to bring the action. So it's 3 years from when you knew or should have known with an outside limit of 10 years. What happens to your document retention policy if there's a claim? Well, we're going to talk about that in a minute or two. So now let's move on to handling claims. So Unlike the Chihuly exhibit in Seattle in front of us, where all of the balls are on a boat, handling claims or potential claims is like juggling a lot of balls in the air. On the one hand, you have to deal with the claim or potential claim, which involves people at all levels of the project, plus management, and inevitably takes up a lot of time. But you also have, most likely, a contractual obligation to continue with the project, and you may also most likely need and want to develop new clients or pursue new ventures. So you've got all these things going on, so how can you handle the claims efficiently? Well, once you become aware of the claim, you need to do three things. You need to immediately identify, preserve, and collect all relevant documentation and information. This information includes all paper and electronic data related to the claim. And the definition of what constitutes electronic data is pretty broad. It includes any information on company FTP sites, Word files and Excel files, pictures, databases, data and archive files. And it doesn't matter where this information is, whether it's on servers, laptops, desktops, backup tapes, personal computers or zip drives or smartphones or iPads, it doesn't matter. All of it has got to be collected and gathered. And you need to suspend a document destruction policy and put in place a litigation hold until the matter is completely resolved. Now, this litigation hold is designed to ensure that all relevant electronic evidence is preserved and not destroyed or altered or modified or compromised. This litigation hold also applies to all individuals who may have relevant information or documents related to the claim. Now, why go through all this trouble? It seems onerous and tedious, but they are critical to the pursuit or defense of a matter, because if you don't comply with these obligations and you don't save and preserve the documents, you may be subject to monetary sanctions. You may be precluded from using certain evidence at trial. A court may allow a jury to draw negative inferences against you, and in an absolute worst case scenario, the court may enter judgment in favor of the claimant. Document, document, document. Once you become aware of a potential claim, the reason why documentation is so important is because memories fade over time and there's staff turnover. People don't have the job loyalty or the desire to stay in one place forever like they used to. So if and when a problem on a project morphs from a potential claim into a full-blown one, or if a claim drags on for a long time, then number one, again, memories are going to fade, people may have moved away, and if you haven't taken the time to capture everyone's knowledge on a particular issue, then you may lose valuable facts that may help in your pursuit or defense of the claim. Next, kill two birds with one stone. Once you become aware of the claim or potential claim, immediately notify your attorney and your insurance carrier. With regard to your attorney, you should be prepared to go through the background of the claim or the potential claim with your attorney. They can help you develop strategies for pursuing or defending, and can help, and through working with them, you can keep this information out of the discovery process and privilege, which is what we're going to talk about next. These strategies could include gathering important documentation and correspondence in one place, maybe preparing a timeline depending on what the nature of the claim or potential claim is, engaging a consultant to help investigate the basis for the claim, and the attorney is also going to help you review the items that should be included and preserved by the litigation hold that we just talked about. Assuming that the loss is a potentially insurable loss, you should also be notifying your insurance carrier. They will assign you counsel, they will set up a file, hopefully they'll assign you counsel, set up a file, and begin an investigation process of their own. Now, here I want to do a special note for the design professionals. Most professional liability insurance policies provide very valuable pre-claim insurance to their insureds. This pre-claim assistance, to their insureds. The pre-claim assistance includes the, again, assignment of an attorney and the investigation to get the good handle on the issue. And oftentimes, this pre-claim assistance is going to help resolve project disputes early, even before they escalate. privilege. So following up on your discussion with your attorney, there are two important privileges that you need to be aware of relative to claims on a project. The first privilege is the attorney-client privilege, and that's defined generally as communications between privileged persons for the purpose of seeking legal advice. By involving your attorney early on, you're going to protect the claim investigation or pre-claim investigation process that we just talked about from discovery, and it's going to protect internal company communications and strategy sessions related to the claim. But be aware that communications with third parties and your attorney present are not going to be privileged. So if you and your attorney are talking in the presence of a third party, then that is deemed not to be privileged. Similarly, in certain jurisdictions, communications with experts are also not privileged. In Maryland state courts, for example, you cannot have strategy sessions with your expert and have that not open and available to discovery by the other side. Some states it is protected, but not in all states. The next privilege is the work product privilege. So the work product privilege is going to cover documents and tangible things that are prepared in anticipation of litigation by a party or their representatives. Now, in anticipation of litigation, it depends on the jurisdiction you're in as to how that's going to be defined. And so you're definitely going to want to check with your attorney in the state where you're located as to how a court would construe in anticipation of litigation. But work product, importantly, does not need to be a communication or confidential, like attorney-client privilege. It does not need to be legal advice, and it doesn't need to be prepared by a lawyer. You all can do it internally. But what do you need to do to make sure that the documents that you're preparing are actually preserved by either the attorney-client or work product privilege? Well, first, you need to make sure that key people in your organization understand the privileges and how they work. They need to label documents with attorney-client privilege or work product privilege if in fact they are so, and that they can't involve third parties in the discussion. If you're going to share the work product with third parties, then you should, for example, if you are a prime architect and have consultants and you're trying to defend against a claim, or you're a contractor with subcontractors in the same position, you want to put in place a confidentiality agreement, a joint defense agreement, or some sort of common interest agreement to ensure that the materials are kept confidential and show that your interests are aligned. And one last suggestion is that if you are interviewing people or talking to people and you want to you should be including your impressions and your thoughts on that same document or legal theories. It will help protect the subject of the interview because courts will protect from disclosure mental impressions and conclusions and opinions of a party's attorney or representatives. So that is one way to protect some work product privilege. And my last suggestion is teamwork makes the dream work. So this is a saying by John Maxwell. And what I would suggest is you should always work as a team, both within your organization and outside your organization. You should have your single point of organization, a single point of contact in your organization for purposes of communicating with the outside. And you want to work with people on your side of the issue to provide a united front and to either pursue or defend your claim. To the extent possible, you want to save any infighting or debates about liability among the other parties for later in the process, and you want to work as a team to defend the claim. The worst thing you can do if, for example, an owner is asserting a claim against an architect and its consultants is for all of you to be fighting with each other and proving the owner's case for them. So that is my presentation. I don't know if anybody has any questions.
All right, thank you very much, Robin. So now for the last 15 minutes or so we have set aside, I just want to invite any attendees to type their questions in to GoToWebinar. You should see a little area in which you can type in your questions. If you have any questions regarding the content that you'd like Robin to answer. I see a few questions that have come in just confirming that you will receive the slides and recording of today's presentation from an email from AIA Contract Documents. You can expect to receive that within the next, I would say, 1 to 2 business days. So at this time, I'm just going to take a quick pause here and just give people an opportunity to type their questions in, and we'll give them about 30 seconds or so here to just kind of collect. And I should have also mentioned that with the email that will go out, the PowerPoint slides will also be included in that presentation. So to start us off, Robin, the first question I see here is, how can you avoid the indemnity clauses from the owner and contractor?
How can you avoid? Well, I'm not exactly sure that you can avoid them. What you can try to do is to work to modify them, to put them squarely within your company's risk profile and what you're willing to accept. What I've found is that when they understand the limits of coverage, some owners and contractors will understand that they want to try to preserve and protect the insurance that you have in place for their benefit, the professional liability insurance. And some may very honestly say that, you know, they don't care. I think it's going to depend on the owner. And that should be, if they're not willing to agree to reasonable indemnification, again, within your firm's risk profile, that should be a red flag. But, you know, to the extent, for example, that they want you to indemnify for failure to comply with laws and codes or intellectual property infringement, you may want to try to tie that to standard of care to bring it within your professional liability coverage. To the extent that they want you to, you know, indemnify, keep it to negligent acts or omissions. And what contractors are often a little more difficult because they have assumed much stronger indemnity obligations or much more difficult indemnity obligations with the owner. For example, they agree to defend the owner, but that does not mean that you should agree to defend them or the owner necessarily, because that is putting significant uninsured risk on you.
Okay, thank you, Robin. The next one I have for you is, can you just clarify the difference between the statute of limitations and the statute of repose?
I can. So the statute of limitations is what you have for most actions. It's a period of time when you have to bring your suit. And from when typically the triggers for when you knew or should have known of the issue. So let's say, for example, that there is you constructed a condominium project, and let's say that you built the project in 2000, and let's say in 2005 you discover that there is a defect. And I'll use Maryland law because that's where I practice primarily. So from beginning in 2005, the clock starts running because you knew or should have known whether there was water leakage or whether you saw some cracking of the foundation and then there was some water that got in there, you know, or whatnot. So you then have 3 years from the date you knew or should have known of the harm to bring your cause of action against if you own there, if you're a condo owner, against the condo association, or to bring your cause of action against whoever you can bring it against. Then, so again, you have 3 years. Even though the statute of repose is 10, you have to bring it within that time. Let's say, for example, you're now at year 9th year, 363rd day, and you now have discovered that there is a cause of action. You now have to get your cause of action filed, and the trigger for that is that it's an absolute bar as to when somebody cannot bring. So I'm sorry. So the 11th year, nobody can bring an action against a design professional or a contractor in Maryland. The different states, again, the statute of repose is different than the statute. The timing is different in different states. Hopefully that cleared it up.
Yeah, thank you. All right, so the next one I have for you is, let's say you're an architect's representative who sees a dangerous situation on site. How should you inform the contractor when they're the ones who are responsible for means and methods of construction?
That is an excellent question. What I would probably do is if you see a dangerous situation as an architect, you've got a duty to the public. So I think that you should I would notify the contractor in writing. I would probably also, if you're an architect's rep, if you are hired by the owner or the architect, that also make sure to notify the person with whom you have a contract. And that way you will be complying with your rights and responsibilities for protecting the public, and ultimately the contractor means and methods should be responsible, and there should be hopefully a provision in their contract which says they're responsible for means and methods, but I think you've got a duty to bring it to the attention of the contractor.
All right, thank you. Next question, can insurance ever cover contractors and subcontractors' errors and omissions?
There is contractor and subcontractors professional liability insurance that they can buy separately from a general liability insurance, but that's typically with regard to design responsibilities and not errors and omissions per se. Typically when they have some aspect of delegated design or design responsibility under their contract, and that is a separate insurance that they would get and that they would pay for separately. And it is a little bit different than architects and engineers professional liability insurance, but again, they can get some depending on what their scope is.
All right, thank you. Next question, is there any remedy to verbal agreements which can later become disputable about work agreed?
I would suggest that you should not agree orally to do any work or perform any service. First of all, most contracts provide that any changes or additions should be in writing. That doesn't necessarily mean that if somebody orders you to do something orally, that you may, depending on your jurisdiction, you may or may not be able to enforce it if there was consideration. Again, it depends on the details. Sometimes changes made orally are enforceable, but again, typically if there's a contractual requirement for it to be in writing, I would suggest you're always best having a written authorization to proceed.
All right, great. And kind of along a similar line here, how do you ensure quality documentation? Should there be procedures that outline the approach, or should this be captured in the contract?
Well, I guess you don't know if quality documentation means like QA, QC, quality assurance, quality control. I think part of that depends on what the client requires. If they require certain things to be provided as part of it. Otherwise, I think each organization should have their own internal QA, QC process, and so they should be following that on a project by project basis. And I hate to use the word insure because insure is a warranty and warranties aren't insurable. But they should have internal processes in place if the client doesn't have a particular process they want to follow, which helps to confirm that they've got good documentation throughout the project.
All right, thank you. Next question is, you mentioned timing of performance with the schedule. Do you recommend attaching a baseline schedule to subcontractors' contracts?
I don't recommend attaching a schedule to anybody's contract for the same reason, is that, you could wind up in a time problem just as well as your subcontractor could. And, then if you wind up in a time problem and then you don't ultimately amend the contract, you could be technically in breach of the contract. So I typically like schedules to be agreed to, but not be a contract document per se. That's the approach that the AIA has taken. And I do tend to think it's a better approach. And if you're going to have schedules, sometimes durations are better than actual days, again, for adjustment purposes and everything else.
All right, great. Sticking to documentation here, which documents take precedence, specifications or drawings?
The answer is that depends on your contract, because typically different contracts will say different things. The AIA takes the position in their standard documents that all of the documents should be reviewed together to provide the intended result. Some documents list an order of precedence of which document controls over what. So that's a very project-specific and contract-specific question or answer.
Figured it would be something like that. It often is. So the next question I see here is, can you just briefly go over the difference between a change order and a construction change directive?
So a change order is where you have agreement between a contractor and an owner on the scope of the work to be performed and the price of the work to be performed. So there's a change in the work, everybody agrees, you sign the change order, it increases the contract sum. If it requires an extension of the contract time, it extends the contract time, and it becomes part of the contract again, it automatically increases the contract sum. A construction change directive, on the other hand, is where there is a change that needs to be made, and there is either not agreement on an extension of the contract time or how much the contractor is going to be paid. So it's basically a written authorization for the contractor to go ahead and start performing the work so that they can get paid. And then they will deal with the details of how the time or a cost will be affected later. And so the way the standard AIA documents work is ultimately if there's an agreement on part of the CCD, the contractor will get paid for the part that's agreed on, and they have a process for how to determine what the remainder of the cost should be, or you just wait until it all gets resolved, and it ultimately gets resolved as a change order. So once the scope and the price of the CCD is finally resolved, then the parties execute a change order which formally increases or adjusts the contract sum and may adjust the contract time.
All right, thank you. So we have about 2 minutes left here. We'll get to one more question here. Thank you, Robin. I know you're powering through these. The last question I'll bring up, and I know you only have 2 minutes to answer, so you may have to kind of abbreviate the answer, but this person is just asking for you to explain and expand upon the pros and cons of an insurance waiver of subrogation provision from different perspectives, so the owner, the designer, and the contractor.
So the purpose of insurance is to take the risk off the party and to put the risk on the insurance coverage. So the reason why the waiver of subrogation is people buy a builder's risk insurance, it's so that the parties agree to waive claims against each other and let the insurance pay for whatever the loss is, rather than have then the parties start suing each other for it. So that is the purpose of the waiver of subrogation, again, is to take on that risk of a loss, of a property loss.
All right. Well, with that, we're coming to the end of the hour. I just want to thank Robin for your time today and for answering all these questions. I know we didn't get to everyone's questions, but if you have any questions about AIA contract documents, you can visit AIA contract documents learn page on aiacontracts.org/learn. And we also have our document content support line that can be found on our website as well if you have any questions about our documents. So we hope that you found this webinar helpful. And again, Robin, thank you so much for your time and your expertise today.
Thanks so much, Sarah. Thank you, everybody.